Hello and good evening. This is Roger Royce with the 10,000 Startups podcast. I'm a corporate partner with Haynes Boone in Palo Alto. And I've been meaning for a while now to talk a little bit about something that happened earlier this year when SpaceX moved from Delaware to Texas after a Delaware judge struck down Elon Musk's pay package. And in that case, it was basically around a lack of independence of the board in that decision. You might remember, and we'll do an entirely different podcast on the business judgment rule and shifting a burden of proof and a need for an independent board and what that exactly means and how it's hard to get to. But for today, I'm more focused on the jurisdictional formation question. You might remember Elon tweeted quite famously something about never incorporating in Delaware about the time that this happened. So, and of course, this wasn't all Elon. This is a shareholder vote type of decision. But in any event, is Texas better than Delaware, or more to the point, are other states better than Delaware? For example, Nevada, because we've been hearing a lot about Nevada for a long time. Now, keep in mind, I am a licensed Nevada attorney, but I rarely form a corporation under Nevada law. Not never, but rarely, because I do startups. And most startups I do are formed in Delaware. Why Delaware? Well, for starters, most corporations are Delaware corporations in this country. At least half of the Fortune 500 are Delaware corporations. And definitely startups are almost always formed as Delaware corporations. Well, why is that? Primarily because the venture capitalists demand it. But that then begs the question, well, why do they demand it? Well, let me give you a couple of good reasons, and maybe we'll compare and contrast that to Delaware, to Nevada, and some other states. First of all, and probably the biggest thing that you might not hear about is that Delaware allows the company to abrogate class voting in its corporate documents, its certificate of incorporation in particular. What does this mean? Well, if you're in California, for example, each class has a right to vote on certain decisions, like a merger or acquisition, sale of the company. Well, in Delaware, we can abrogate that and we can have all the classes vote together. So if you're an investor in a company and you're getting preferred stock and the founders have common stock, a different class of stock, well, you don't want to give them a veto right over a sale of the company if a majority of all the shares want to go along with it. It's a big deal. It's one of the big reasons, not the only reason. It's commonly said the conventional wisdom is that Delaware has this well-established body of law, and there's lots and lots of case law interpreting what the corporate law is in Delaware. And that's very true. And you don't get that for sure, not in Nevada. They just don't have that kind of case law. So you have a lot more certainty. It's also said that Delaware courts, like East Coast courts generally, are much more inclined, certainly more inclined than California, to interpret things the way they're written. In other words, to be much more strict constructionists, and that gives certainty to business transactions. A couple of other things: the Secretary of State's office in Delaware is very service oriented. That's what you think about when you deal with their Secretary of State. Not like that in every state. Certainly not like that in California. Delaware law allows for broad indemnities, which was recently expanded so that officers can be covered as well, provided that certain magic language and provisions are placed in the corporate documents. Nevada has an even broader indemnity I'll talk about in a minute, which is just automatic. I think you could say overall that Delaware is very protective of shareholders, because everything that I've just said, as you can imagine, are things that would very much appeal to investors, i.e. shareholders. Now, one downside before I leave this of Delaware, and this is just an annoyance that affects every corporation in Delaware, is that the state will generate an automatic franchise tax notice, which will calculate the state franchise taxes in a way that is almost always far more than the company owns. And they'll get that notice. And it's up to the company then to calculate the franchise tax using one of alternative methods, which will almost always certainly result in a fairly noise level tax. And it's just an annoyance because you get this and then you have to recalculate. So it's one, and every once in a while, I know that somebody might make the mistake of actually paying it without doing their own calculation, which can be a disaster. Now, Nevada, it's often said that the advantage of Nevada is that they're the only state that doesn't share information with the IRS. I don't know if that's really an advantage at all. I mean, the IRS has so many tools at their disposal. First of all, why do you care? And secondly, if you do care, you should know that the IRS has so many tools available for getting information that I'm not sure that's that big an advantage. And I'm speaking as a Nevada licensed attorney. Now, the real advantages are that Nevada is generally very protective of management, right? Whereas Delaware is protective of stockholders, Nevada statutes are relatively protective of management. There are automatic director and officer protections. The amount of exoneration and indemnity can be pretty broad in Nevada, broader than Delaware. You can indemnify for breaches of loyalty, for example. It's harder to remove a director in Nevada than it is in Delaware. There is a pretty robust anti-takeover statute that's way too complicated for me to talk about now. Let me just say Delaware, or Nevada rather, does have an anti-takeover statute. Interestingly, for smaller corporations, there's a charging order in Nevada. Now, let me explain this for a second. A charging order concept is something that came out of the common law in partnerships. And the idea was if that a partner in a partnership had a judgment against them, and there were a creditor that levied on their partnership interest, well, they couldn't go in and blow up the partnership, right? They couldn't all of a sudden become a partner in the partnership because that's an agreement. And the other partners, the non-debtor partners, they made an agreement with the debtor, not with the debtor's creditors. But what they could get is an order from the court that allows or that forces the partnership to make any distributions that would be made to the debtor instead to the creditors. So it's a charging order. It's not something you really want to have, and we could spend an hour on that because of the tax aspects, depending on whether you believe that theory or not. I do. So interestingly, you don't have that protection in corporations generally. Creditor levies on a stock, they sell the stock, now they're a stockholder. They got voting rights because they are attached to the stock. Well, Nevada says, this charging order rule makes a lot of sense. We should have that for smaller and certain types of corporations as well. Interesting aspect of Delaware. Again, as you can see, not so protective of the shareholders, more protective of management. And then finally, Nevada, I don't know if this is an advantage or disadvantage, but they do have business courts. So, but the downside is you might be in front of a jury. Now, and that may be an upside or downside. Most people, depending on where you are in this, if you want certainty, it's probably a downside. Now, it's interesting to have business courts because that is one of the advantages of Delaware is that the judges are used to hearing business disputes. They understand the law very well. If you're in another state, for example, California, you might be in front of a judge who does not have a business background, for better or worse. So Nevada, you could probably get it removed to a business court. That's what I understand. I'm not a litigator, but that's how I understand it works. Disadvantages. The big one is I used to do a lot of Nevada corporations. The one thing, it sounds odd, that sort of stopped that was when they adopted a business license requirement, which is relatively expensive. So the filing costs are high in Nevada, and there is this requirement, even if you're not doing business in Nevada, that a Nevada corporation get a business license. A couple of other things. For an LLC, for example, it has much less privacy because a list of managers has to be filed and it's public record. And then finally, there's a reputational aspect. Delaware is just gold standard, known throughout the world. It's hard to beat that. in any state, although there's a few of them that are trying. Wyoming comes to mind. Now, the last thing I want to mention, and really the whole point of this very brief podcast, is to focus on the director and officer liability, because there have been some recent case law in Nevada that was more procedurally had to do with burden shifting. But again, as I said, Nevada is relatively management friendly. And Nevada has this really interesting statute. There's been I learned that the duty of the directors was owed to the company and its stockholders. That is definitely the rule in Delaware. And I always viewed that as meaning that it was their obligation to maximize shareholder wealth. That's how I learned it in economics class. Now, I know some people say it's a little more nuanced than that, but generally, the duties are to look after the interest of the stockholders. Well, Nevada has a statute that says that the directors and officers may consider the interest of the company's employees, suppliers, creditors, customers, the economy of the state and nation, the interest of the community and of society, and the long-term and short-term interests of the corporation and the stockholders. Holy cow. I mean, that's kind of like everything in the world. It sounds a lot like benefit corporations in other states, but that's right in the statute. So take that for what it's worth. Again, I view that as a management protective statute. Again, making it much more difficult to sue directors and officers in Nevada, all other things being equal. So that's it. That's it at a high level. At the end of the day, this is fun to talk about, but I will tell you that for venture-backed companies, we're going to go to Delaware. For smaller, closely held companies that are doing business in Nevada, we're going to go to Nevada. The last thing I would say, again, I could spend an hour talking about the tax aspects of this, but Nevada and Delaware both do not tax corporations. Well, Nevada, they don't have an income tax. Delaware won't tax a corporation that's not doing business there, that just incorporates under Delaware law. But I oftentimes have people come to me even now and say, look, I'm doing business here in California. I'm going to incorporate Nevada so I don't have to pay California tax. I will just tell you that does not work. Keep in mind, there are state tax mitigation strategies, but that is not one of them, right? California is going, like most states, is going to tax, if they have an income tax, they will tax based on various factors that measure economic process within their state. And that is a whole nother discussion in itself. However, for a small, closely held company, or maybe even a bigger one that actually is doing business in Nevada, if that's where their office is, if they're not venture backed, and if they don't have shareholders that are insisting on Delaware, then Nevada might be the right choice. But I don't think it's going to replace Delaware anytime soon. This is Roger Royce with the 10,000 Startups Podcast. Thanks for joining. We'll see you next time.